Speech is silver, silence is gold. Our constitution has many folds. Each fold makes the people bold, the rich and poor equally enrolled. Let's uphold it forever as it binds us all together. Honorary dignitaries and all my dear fellow countrymen, good morning to one and all watching me. This is Bhakti Waghmare from Solapur. I will be discussing on the basic structure of Indian Constitution and constitutional amendments. Speaking about Indian Constitution, it is the longest written document of any sovereign nation in the world. Provides a comprehensive framework to guide and govern the country, keeping in view her social, political, cultural, and religious diversities. Longest as it embodies the modified results of 100 plus amendments, judicial decisions, and detailed provisions. Constitution framed by the Constituent Assembly provides a basic framework for political system, rights and duties of the citizens, and structure and limitations on the government that this nation ought to follow. Constitution is not merely a legal manuscript, rather it is a vehicle that steers the nation to realize the dreams and aspirations of the people by accommodating and adapting to the changing needs and realities of the time. And that is where amendments come into focus. Amendment is a provision given in the Constitution itself. The procedure is where you make changes to the nation's fundamental law. Process for this is given in Article 368, Part 20 of our Indian Constitution. The process is seen to be partly flexible and partly rigid, as the amendment can be initiated only by introduction of a bill in either house of the parliament, that is, either in Lok Sabha or in Rajya Sabha. Then the bill must be passed by each house of the parliament by a majority of total membership of that house and by a majority of not less than two-thirds of the members of that house present and voting. This is called as a special majority. Whenever there is the involvement of the states, there is the need for a ratification of the bill by not less than one half of the state legislatures. Also, there is no provision for joint sitting in case of any disagreement. And finally, the bill is presented to the President for his or her assent. Till now, Indian Constitution has gone through tremendous changes over these 7 decades. Starting with 395 articles and 8 schedules, today it stands with 450 articles and 12 schedules. Amendments are related to the matters like fundamental rights, democratic reforms, territorial changes, and creation of the mechanisms that is the one which was created in the time of the Panchayati Raj, etc. Some important amendments can be seen as 42nd Amendment Act of 1976, which is also called as a mini constitution, as it is the most comprehensive amendment in the history, which added fundamental duties to the list. 61st Amendment Act of 1988, where the voting age was decreased from 21 years to 18 years. 73rd and 74th Amendment Act of 1992, where the concept of local self-governance was brought into frame, etc. The Constitution can be amended any number of times by the Parliament, but only in the manner provided. That is, the only and the current limitation on the amendment power of the Parliament comes from the Keshavananda Bharati versus the state of Kerala, where the Supreme Court ruled that amendments must respect the basic structure. That is, no harm should be made to the basic structure while amending the Constitution. Parliament attempted to remove this limitation by enacting the 42nd Amendment Act, which said that there shall be no limitation on the enacting power of the Parliament. However, later Supreme Court declared this as invalid and the basic structure was upheld. There is no any mention of the basic structure in the Constitution. Rather, it is a concept evolved gradually over time with the Supreme Court judgments. Basic structure doctrine helps to protect and preserve the spirit of the Constitution. It includes some important things like supremacy of the constitution, sovereign, secular, and republic nature of the state, also the independence of the judiciary, the harmony and balance between the fundamental rights and rule of law, etc. In the past, we have seen that some amendments in the past were not made to strengthen the constitutional, what you can say, the protections, but for self motive. That is why we can say that frequent amendments can be politically motivated. Other critics include the unavailability of any special body for the sake of amendments. There is exclusive decisions of the parliaments only, less saying to the states, less attempt for the judicial intervention, etc. Despite these shortcomings, we cannot forget that these amendments have proven to be easy, simple, and successfully fulfill the society's changing needs. That is the one we saw in the 128th Amendment, which is also called as the Nari Vandan Adhiniyam, which reserves one third of the seats for women in union and state assemblies. Recently, Chief Justice of India D.Y. Chandrachud, speaking about the importance of the basic structure, compared the basic structure to the Dhruvatara. Dhruvatara, which always shows you a correct path every time. Also, Dr. B.R. Ambedkar once said, however bad a constitution may be, if those implementing it are good, it will prove to be good. And that is why I think somewhere we, the people of India, are responsible to use this amending power as a wonder blessing by choosing the responsible representatives in the elections. Thank you. Jai Hind.